Mr. Farias, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. This is how you understand this agreement.
I'm sorry.
You have two agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record, they're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose.
Pause right here. This is one of the most misunderstood moments in criminal court. The judge isn't threatening him. This is a legal warning about collateral consequences. Once you've got convictions, every future police encounter changes. No benefit of the doubt, no clean slate. The system remembers everything. And that's what the judge is really saying. This case doesn't end when you leave the courtroom.
Pick up multiple successive cases. It kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. Just, that's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. You understand? For you to complete this successfully, you have to do a batterers intervention prevention program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to one time a week for 8. You don't have to do this. We can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Attitude, Judge, is just, I mean, I understand, I messed up. I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, it's just.
And here's the thing, though, Mr. Farias, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
This is a conversation.
It's, no, but Nathan, I want him, how did we treat you in what way?
I mean, I'm not
Tell
saying
me.
y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20.
That line sounds dramatic, but legally it's accurate. A deferred adjudication isn't a free pass. You waive your right to trial, appeal, and challenge evidence later. Miss one condition? The judge can sentence you without a trial. That's why judges slow this moment down. This agreement is mercy with strings attached.
Whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody. But I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, I don't, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it. You know,
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
well, hold on a second. How old is the case? I mean, the case is from 20, it's 510 days old? No. We set the case for trial today.
We'll do that.
That's it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand, the way I talk to you now is in hopes that you don't pick anything up in the future,
I
because
promise you I haven't.
do you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every-
sure you do.
Same.
But I'm the one that I am one of those persons that means it when he says it.
I'm gonna hit the pause button.
You pick up a case in 2020 and now you pick up a case in 2023.
I'm gonna hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you, but what you're pleading guilty
No,
to carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today, get convicted, which is what you're planning on doing. The second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we,
Oh, I'll just set it today because it'll be long enough that we can have a conversation. Almost
So-
30 or so days, Judge.
yeah, November 19th. That's,
That's fine,
it's over 30 days.
Yeah.
Okay.
It's not that. It's just that I don't remember when Thanksgiving is. Which is a week or two after that, so we're fine.
It's that Tuesday. So it's the Tuesday before.
Tuesday, the week before.
Correct.
We're fine.
Okay, 11/19 it is on both cases.
Is Ramona in the back? Do I need to go talk to her?
Yes, no. Well, I'll tell them, but don't let
Oh,
them leave.
Nathan, you're fine. It's a good day.
Thank you, Ramona.
You're welcome.
Who said my name? Yeah.
This is Mr. Wiley, another plea, Your Honor.
It's not a big deal. Good morning, Mr. Wiley.
Good morning, sir.
Mr. Wiley, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in Harris County Jail. How much credit does he have?
71 days.
71 days credit that you already have. You're giving up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept.
This is actually a huge judicial integrity moment. Judges cannot accept a guilty plea if the defendant says they didn't do it. That's not drama, that's constitutional law. A plea must be knowing, voluntary, and truthful. If you say, I didn't do it, the plea dies right there. No shortcuts.
Is this what you want to do? How do you plead to the offense, sir? I will find you guilty, sentence you to 3 days in jail, give you credit for the 71 days you've done. I will roll your car costs, you won't owe anything, and good luck to you, sir. Thanks. Thanks, sir. Good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On September 8th, 2024, an officer was dispatched to a target in Harris County, Texas regarding a theft. Upon arrival, the officer met with the complainant, the loss prevention manager, who advised the defendant had stolen from the business. The complainant advised that the defendant had entered the business with no merchandise and with a small pink fanny pack on her person. The defendant was then observed going to the style department and began making selections at the merchandise and then began going into the business fitting room. The defendant exited the fitting room and the style merchandise was not seen, and the defendant dumped the merchandise on the rack in the fitting room. The defendant was then observed going to the jewelry department, and the complainant advised the defendant was observed quickly selecting Kendra Scott jewelry, and the defendant went to the beauty department and was advised that she began selecting Kendra Scott jewelry and hair care department merchandise. And the defendant then went to the home department and then the chemical aisle and began concealing merchandise into the small pink fanny pack and began walking towards the front of the store. The defendant passed all points of sale without rendering payment for the items, and the total amount taken was was $103.92
Okay, where did you say this is from?
at Target.
Got it. Okay. Ms. De La Cruz, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am?
19.
What do you do for a living?
I go to school,
Where do you go to school?
Pima Medical Institute.
Okay. Are you working as well?
Not currently.
Who do you live with?
My parents.
Are they here today with you? Okay. Like I said, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Target stores whatsoever. You were given a free bond, so we let you out of jail. And that's how you're here before me. You're not going to get another one. If you pick up a new case, if you go to any Target or do something you're not supposed to, I will revoke the bond, put you in jail. You will not get any more PR bonds, and it's going to go way higher than it is now. Do you understand? Did you want to apply for a court-appointed lawyer, ma'am? Okay, we will give you an application. I'm going to have you go to Victoria, sign a reset. After that, we'll have you take your seat in the jury box. Do not leave until you sign our bond conditions out, okay?
Where do I go for it?
First, we're going to have you sign a reset, and then we need to give you an application for an appointed lawyer. I need to know everything about you, and then we'll have you take a seat in the jury box. Please. Good morning, Mr. Javed.
Good morning.
Sir, you're charged with terroristic threat or a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 8th, 2024, in Harris County, Texas, an officer was dispatched to meet with a firefighter at 3515, a residence in Harris County, Texas. The officer met with the complainant, who stated she got into an argument with her husband, the defendant. The complainant stated the defendant had been threatening to kill the complainant's family in Pakistan and to kill her in the past. In 2023, she called the police, but no report was made because she was afraid of retaliation. The complainant stated they have talked about who the defendant knows in Pakistan and believed the defendant could do something to her family to have them killed. The complainant stated the defendant made these threats to her and her family to control her. When the complainant called for police on October 8th, the defendant told the complainant if she called the police, the complainant knew the consequences, while making a circle in his hands, gesturing as if to strangle the complainant.
So there's also felony retaliation.
Yes, Your
Is
Honor.
this within what you just said now, or is it something else that happened? Because I know it arises out of the same, but was there any more overt action that was done other than spoken word?
Sorry, Your Honor. Let me check the DIMS.
Mr. Javed, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Yes, yes, sir.
I'm ordering you as a condition of your bond not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I'm entering in, or it looks like a protective order has already been issued on the 9th of this month. I would get to know it. If you do something to violate this protective order, the state can and will file additional charges as violation of protective order. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on a no contact order, I can hold you at zero bond. And I will do it in a second to protect every person of Harris County. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. Phone calls, text messages, social media, use of another person to relay any information. I'm also ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
If you violate these conditions, I will revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. And I'm telling you now, I'm going to make it high. So no contact of any kind.
Your Honor, appears to be just the verbal threats.
Okay. So can you file no contact and no weapons, please?
Yes, Your Honor.
For now, I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign the bond conditions, and then we'll have you wait for your lawyer. Okay? Please.
All right, page 12. Go ahead and sign the consent.
Mr. Dakota, do you have an arraignment?
No, sir.
No? Okay.
Cubone? All right, Judge, page 19, Perkins, come on up.
Silence all cell phones.
Good morning, Ms. Perkins. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 9th, 2024, officers were dispatched to 5299 West Park Drive in Harris County, Texas, regarding a major crash. The will witness stated he saw the defendant get out of the driver's seat of her motor vehicle, and Houston Fire Department advised the defendant admitted to drinking. The officers observed the defendant with slurred speech and glassy eyes. Standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn was 3 out of 8, and one leg stand was 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.153 and 0.157.
Tell me about the driving facts again, please.
There was a major crash, Your Honor.
Okay, so she's at a crash.
She's at a crash, and then the real witness who was involved in the crash saw the defendant get out of the driver's side.
Got it. Okay. Ms. Perkins, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? Can you run her license, please?
Yes,
And
sir.
also, does she have any prior DWIs, please? If you
No
can run
prior
her
DWI
license.
and license eligible.
Okay, ma'am, I'm going to find, like I said, there's probable cause to go forward. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. I'm going to revoke your bond. You will not get any more PR bonds. Do you understand? How old are you, ma'am? You're 20. What do you do for a living? Where do you work? Mom shells. Who do you live with? No, with mom, dad, or by yourself? Okay. Can you afford a lawyer? How much money do you make a month? Okay. Is that all you're doing now, or are you doing anything else?
This is where people emotionally shut down, but the law doesn't care about feelings. Enhancements are automatic. Second family violence assault, felony. Second DWI, mandatory upgrade. The judge isn't judging this person. He's reading the statute. Same charge, same consequences, every time. No discretion, no sympathy clause.
Okay. You will need to meet with the pre-trial for your bond conditions, so don't leave until you do that. Okay? Please. You have an arraignment. Are you ready?
I do.
We have to do it right.
Yeah.
Whenever you're ready.
Yes, we have another arrangement.
You want to do Corey's first or?
Is that arrangement?
Yeah.
Oh, who was it?
Cubone.
Oh, that's the one else.
Is it Cubone?
It's fresh. I'm not exactly sure how to pronounce it.
How do we pronounce your name, ma'am? Cubone. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay?
Yes, Judge. On September 18, 2024, the officer was dispatched to a Walmart in reference to a theft in Harris County, Texas. The officer made contact with the loss prevention manager, who stated he followed the defendant in pink nurse scrubs within the business as she was pushing a shopping cart and concealing in a black backpack several items she took from the shelves of the business. The defendant observed the defendant pay for the items in the cart at the self-checkout, pass all points of sale, and exit without paying for the items she had loaded in the backpack. The complainant stopped the defendant outside the exit doors and confronted her about the concealed items. The defendant initially denied everything, but ultimately gave her the backpack, to which the defendant found unpaid items with a value of $118.53. Another unpaid item of a value of $1.38 was found wrapped in a Walmart plastic bag in the shopping cart. The total amount taken was $119.91.
Okay. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen? You are? Okay, I am ordering you as a condition of your bond not to go back to any Walmart. If we find that you go back to Walmart, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand? Okay. You have a lawyer. Because you have a lawyer, I will waive your appearance. So you don't have to come to court until he tells you that your presence is needed. But you must stay in contact with Corey. If he tells me he can't get a hold of you because you're ducking and dodging phone calls, that's it. We will revoke your bond, okay? Any questions? Yeah, I know. I have to apprise you.
I understand, yeah.
Do you have any questions? Okay, we're gonna have you sign a reset. After that, we'll have you take a seat in the jury box. We get your bond condition. We'll have you sign it, and then you're free to go. Okay?
Thank you, Judge.
Okay, guys. Thanks, Corey.
Judge.
Where's the slip?
And it is no, it says 3 days Harris County Jail. I spoke with the state. It is a time certain.
All right, good morning, Mr. Reyes. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. It's even there after you die. And this is important because you ever get pulled over and an officer's going to see this. If they smell alcohol or dope, what do you think they're going to do? Right. What we're doing today, the proverbial slap on the wrist, now you'll be facing a minimum of 90 days in jail. So be careful because this time served, you understand. I mean, it's a minimum of 90 from now on. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen or possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. It will go on your record. It will be there forever. Is this what you want to do?
Sure.
How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty and I will sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I have to suspend your license, so I will suspend it for 90 days. Do not drive until you get a license, and good luck to you, sir.
Judge, I asked that his license not be suspended. It's been suspended for over 220 days already.
I have to suspend it, right? If you want credit for the ALR suspension,
Yes, sir.
why has it been suspended for so long?
I am not very sure. He just spoke. I'm filling in for Attorney Clay today, Eric Clay. So I just spoke to the client about the suspension.
Part of my PR bond was not to drive, and you revoked my privilege to drive. So I've been.
Well, there's a reason. Usually, if you don't have a license, you don't have insurance.
I don't have a license
Over a .15.
No, I never take someone's, has to have been an aggravating factor as to why. I don't just willy-nilly take someone's ability to drive away, because I take it really seriously. You know, if you're driving in a manner like going over 100 or a prior DWI or with an open container or something like that. What happened in this case, Alex?
So in this case, officers were dispatched to a crash in Harris County, Texas, and they arrived and observed the vehicle with front end damage that had hit an apartment complex entrance gate and wall
You
building.
have a license.
I had a license, valid license and valid, liability.
See.
Part of my bond was, suspended my license, I couldn't drive.
Oh, you know what it was? You had an ALR suspension. That's one. Your license was suspended. Have you paid any kind of reinstatement fees? Then your license is suspended now. Whenever you get a DWI, you have two cases against you. You have this case, you also have an administrative case versus DPS. And if you don't take care of the administrative case, DPS suspends your license, and it remains in suspension until you go and actively take care of it to have it reinstated. One of those things that you have to do is pay a reinstatement fee of around $125. So until you do that, it remains effectively suspended indefinitely until you take care of it. What we do is we bring you back in to apprise you of the fact that your license does become suspended, and that if you drive, you're in violation of these bond conditions. So I'm trying to help you, believe it or not. You know, I'm not. So do this. Go get your license reinstated. Go to DPS. Show me that you've got it reinstated. Then we can run so that I'll give you credit for the time that you've had your ALR suspension. I'd rather have you driving legally than, driving illegally, right? So go get it reinstated, because what we need are the dates of suspension for the ALR. If you have that, we can give it to them and give you the credit.
Yes, sir.
But don't just start driving now. Your license is still suspended. Alex, can you run it? You mind?
Yes, Your Honor, it's not eligible, and the most recent we have is the ALR suspension.
See? It's the administrative license revocation suspension that you get from DPS. You got to go call DPS, and they'll tell you what to do to get it reinstated. All right?
Thank you, Judge.
Okay, guys.
Thank you, excuse.
Thank you.
Please. Hey, apellido? Macero.
Page 14, Your Honor.
Thanks. Mr. Macero, you're charged with failure to identify oneself, giving false or fictitious information. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to an attorney. If you cannot afford one will be appointed to you.
All right, may I just get a cause number for that real quick?
It's 2533067.
On October 8th, 2024, the officer observed the defendant's motor vehicle fail to stop at a stop sign. A traffic stop was initiated. The officer made contact with the defendant. The defendant stated he did not have a driver's license, ID, or passport. The defendant wrote Jesus Gutierrez, date of birth October 2nd, 1977, on a notepad provided by the officer. There was no TCIC return for the name. The officer observed the defendant's motor vehicle to have a different VIN from that on TCIC, and the defendant consented to a search of the motor vehicle. The officer found a Venezuelan passport with the defendant's photograph and the name Jairo Jose Macero Barcenas, date of birth January 11th, 1976. The defendant stated he lied about the name to the officer and used a fake name because he was afraid and had never been stopped by officers while in the country.
Mr. Macero Barcenas.
Your Honor, he has to go to the civil trial.
Yeah, go. Thanks, Luis.
Hola, buenos días. Me llamo Luis Sendar. Disculpe la interrupción. Mi colega se tiene que ir a un juicio. Acérquese aquí, por favor. Solo mire el juez y conteste nada más en español. Pedro.
Marcelo Barcenas, I'm going to find that there's probable cause to go forward with your case. Are you a United States citizen?
What? Solo
Are
mira-
you a
mira-
United States citizen?
ciudadano estadounidense?
No.
No.
Are you in this country with or without permission?
¿Es con permiso o sin permiso?
Sin permiso.
Without permission.
I'm going to give you a warning now that if you go to jail and immigration finds you, they will put an immigration detainer on you. You will remain in custody until this case is over with, and then you will be shipped off to immigration, and you will sit in immigration custody until they do whatever they're going to do to you. That usually is a process that'll take about 6 to 9 months. If you do not want that to happen, do not violate any of the conditions that I put on you now. Because if you do, you could be spending a lot of time in custody. You do not have a Texas driver license, so you are not allowed to drive. I am making that a condition of your bond. The other condition I'm putting now is not to get in trouble or violate any laws. You were able, or I don't know if you went to jail, but from now on, you will not be given any more PR bonds. So your bonds will be sufficiently high that you're going to spend some time there. And if you're unlucky enough, immigration will put a detainer on you. You will get no further warnings. Do you understand?
Sí, señor. Tiene que hablar. Sí, señor o no, señor. Yes, sir.
No driving whatsoever.
Manejo para nada. No puede manejar.
Okay. We are going to reset your case to give you time to hire a lawyer. First, I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria, where we will have you sign a reset, and we're going to get you out of here. These are the only conditions I'm putting on you now. Don't drive and don't get in trouble. When you come back, please have a lawyer, sir. How was jail? Good. You pick up another case, you violate conditions. Next time, it'll be double, triple, maybe quadruple, depending on what happens. I'm not asking much from you. I'm asking you not to consume alcohol or illegal drugs and obey the law. And if you become a danger to society, there's only one place. Do you understand?
Sir.
Okay. Like I said, I'm not asking you to split the atom here. Just be nice. It's not hard. So bond condition will, so this is Ochoa Lacan.
Yes, Judge.
I'm letting pre-con know. So, he's in the jail docket? Yeah, it's page 29, guys. No drugs, no alcohol, random urinalysis. Alex, can you run his license to see if it's eligible or not?
Yes, Your Honor.
Whatever happened with the investigation that they were doing, do you know? With the interference?
I checked them. They didn't file anything. Nothing new has been filed.
Alex, do we know anything about the investigation? Do we know any other further charges that are potentially going to be filed?
I don't see anything about the sexual assault investigation, so,
Okay.
and also his license is, I apologize, it just closed out, not eligible.
I'm ordering you now not to drive. Your license has been suspended, probably due to the administrative license revocation hearing. So I'm going to have you sign an affidavit with me today, Mr. Ochoa Lacan. You're not allowed to drive. Do you understand? We had them check in the system now with DPS to see if it's eligible or not eligible, and it is not eligible.
And Your Honor, you are correct, it's the ALR suspension.
Do you understand? So if you drove here, you may not drive home. You've got to find somewhere else, someone else. Do you understand? You violate these conditions. Like I said, you're going to be signing an affidavit. This is a promise you're making to me not to drive. And I'm telling you, there's no better way to see me really get upset than to drive when there's a no driving affidavit. Do you understand? It is your responsibility to get with DPS to try to figure out how to get your license back. And if you do, and you get liability insurance, I'll take this off. But until that point, don't drive. So I will have you come up here, swear to us that you're not going to drive. we will have you sign a reset. After that, you'll pre-chop for your bond conditions, and after that, you'll be free to go. Okay?
Judge, if I may, he is here this morning on the DWI. The interfering is set for Friday. Is there any way we can handle
No.
both of those today?
Have you come multiple days?
Okay. Come back on
Kidding,
Friday.
of course.
I was like, thank you, Judge. So
Yes.
are there gonna be different conditions for that or the same
No,
conditions?
it'll be all in one. That's why I was in the interference, I was wanting to see if there's a complaining witness to forbid him to have contact with, but it looks like the interference is just with an officer, so I'm not gonna put any conditions on that one. Everything just rides on the DWI. So you know what's expected of you. You're skirting thin ice. Be careful. That ice breaks. Okay? That way.
Thanks, sir.
Take care.
Again, on Javid, we've gotten in touch with the complaining witness on this case. And
Hello, I'm ADA Colada. I'm filling in for Conrad.
Come up. Come up. Yes. Ms. Turner, I truly appreciate your tenacity. I really do. But the allegations to me are serious. And guys, keep it down, please. And I don't know if I'm ready because I don't want something to happen. It's too soon. It's too fresh. I don't want something bad to happen.
is it possible for us to keep the address restriction and just do no threatening and harassing?
That's what I mean. It's the same thing. It's the same thing. That's what,
Because they have no contact at all if we do no threatening and harassing. They can still
don't
communicate,
have
but they,
contact. That's the point, is I don't want you to have contact with her. The allegations are serious. You allegedly threatened to choke, you allegedly threatened to kill the family, do it overseas, and it's in a repeated fashion.
she said today that that wasn't true.
That's
I don't
not what
know
I was
that.
told on the recall, sorry.
Okay,
That's not what I was told on the recall. She said that those statements were prior incidences where he had made those comments and that the incident in question where he made the threat, the consequences of calling the police, she's claiming that he never made the gesture, but I don't have the body cams to watch it to see if that's actually what was said, which is why we're holding off on making a decision.
So what is your position? Your position is to keep no contact?
My position is no threatening or harassing. Based off of the complaint, it was very clear that she doesn't want the restrictions. And I think that they will contact each other anyway. So rather than setting the defendant up to violate his bond conditions.
No. There's no setting anyone up. We're clear what the consequence is if you try to have contact with her. Don't want you to have contact her for the time being now. I want you to appreciate the fact that you're not to have contact with her, and I'm warning you, don't do it. There will be severe consequence if you try to have any contact with her, if you try to use anyone to relay any kind of messages. If I deem you a public danger, Mr. Javed, I'm telling you now, I'm going to revoke your bond and I'm going to make it very high. Perhaps in time, yes, but the allegations are there. I find them disturbing and I don't want you to have contact with her. I know that your lawyer has really worked hard for it, so don't blame her. It has nothing to do with her. It's all to do with me. And I'm ordering you now not to have any contact with her. Do you understand?
Yes.
Don't blame her. If you want to blame anyone, you blame me. But for the time being, no means no. It doesn't mean maybe. It doesn't mean I've got kids. It doesn't mean I've got to get my car payment. It doesn't mean I got to get my house done. None of that makes a difference to me. My only concern is public safety. That's it. Do you understand?
Yes.
I'm not ready yet. The allegations to me are very troubling. And I get the fact that people try to either renounce, mitigate, recant, but I'm not ready yet. I'm just not. In time, perhaps, because, I'm always willing in time to, modify, it's just too soon for right now.
Okay.
Are there any kids in the relationship now? Good, wonderful. So there's just no reason for you to have contact with this person for now. There's no reason. Don't. Time heals all wounds, and perhaps we can change it, but for the time being, no contact. Come back in a couple weeks, and then we can redo it. And then I want you also to give you guys sufficient time to do a full rip, take time to do it the right way, not in a rush when you've got other, a gajillion things going on as well. And I appreciate you really coming down to help out as well, okay?
Problem, and I'll make a
So-
note for Conrad to have a more in-depth discussion.
The other thing is I'd like to talk to her as well, before, because I'd like to talk to her to tell her that, the ramifications, not to ever feel any type of fear. No one, absolutely no one should have to live in fear like that. It just doesn't matter. It doesn't, imagine having to walk on eggshells because of the fear that if you make someone mad, they're going to explode. No one should have to live like that. So, and I'd like to impart that, that's it. All right. So, Mr. Turner, whatever reset you want, if you want to do a week, 2 weeks, whatever you'd like to do, I'm okay. I'm just not ready. And understand that just, I bet, best probably not to say anything. Okay. All right. Thanks. All right.
I'm making that note for Conrad now.
Thank you. Hi, counsel. Coming up. Hey, of course. Hey, what's new?
How are you?
Hey.
I didn't realize you
Hi.
had created for the holiday.
Yeah, so we're gonna expect you to be in costume in about, 2 weeks as well. We all will be. So.
I'm on call that week, so I told my second out if he wants to be Catwoman, I'll be Batman, but I don't know if we're gonna actually end up doing it.
And I'm already in costume.
As it's a good costume.
I'm faking it, Joe.
Who you got?
We have Mario de Jesus. I'm sorry, I lied. Horacio Guijarro.
It's a bond.
250-6632.
250-6632.
Yes, Your Honor.
Okay. Oh, is this the one where there's a dead body?
Yes, sir.
Okay, so,
And we do have family in the courtroom, Judge, just so you're aware.
okay.
My division chief is currently in trial on an intox man, so I'm hoping to sit down with her in the next 2 weeks so we can go over this case and make the final decision about whether or not we're gonna upgrade it. Matthew and I have been in pretty much constant contact about it, but
The issue, is it causation?
Causation, Judge.
Always causation, always causation.
She's been great. I mean,
I know, I know her well.
I keep
Great.
telling him to spread the rumor that I'm very difficult to work with, but he won't do that.
What do you get? So you want more time?
Yes, please. If the court doesn't mind, I think 2 or 3 more weeks and I should have an answer.
Okay. I've not gotten any violations. I've gotten everything.
No, sir.
that's good so far, so, okay.
And you did
Yeah.
want to talk about bond,
There's
right?
one other issue, Judge, if we can address is one of the bond conditions. He's on GPS, got scram, he's abiding, but his curfew hours, he's just having issues with work.
Okay,
Instead of 7 to 7, push it from 6 to 8.
I'm okay with that. Yeah. Just, I don't want him out in the middle of the night, but I'm okay with that. Absolutely. That's okay. And if you want, 9 to 6, I'm okay with that. What did you say you want?
9P to 6A.
Okay, yeah,
That's how I think. Judge.
okay, totally. So just let pretrial know and then we can amend the conditions and then, it's getting up there. It's 180 now, so at the next setting, we gotta, yeah. Okay, cool, okay.
Very nice to see you.
All right,
See you,
guys,
Judge.
take care, for sure.
Jairo Jose Macero Bárcenas.
So guys, he's got to be here at the next setting.
Yes.
Okay. Good morning, Mr. Molina. So you're charged with 2 cases. You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You're facing a year in jail and or a $4,000 fine. You're also charged with theft. On that one, you're facing up to 6 months in jail and a $2,000 fine. Shh. You guys have worked out an agreement. They're going to dismiss the theft in exchange for your plea on the DWI. You need to understand that the DWI will go on your record. It's going to be there forever. What do you think will happen if you got pulled over after a night of drinking and an officer sees a prior DWI in your record,
caso de manejo
what
ebrio,
do you think is going to happen?
¿qué cree que le va a pasar a usted?
Regreso a la cárcel.
I'd return to jail.
I would never, even if you've had one beer, get in a car because your record will kill you. And what we're doing today, you'll be facing a minimum of 90 days in jail if you ever pick up another DWI. Do you understand?
¿Entendió, señor?
No more proverbial slaps on the wrist. You're facing, like I said, up to a year. You've worked out an agreement. They're offering you 3 days in jail. Credit for the 3 days that you've done.
De cárcel, crédito por los 3 días que ya cumplió.
It also says here $650 in restitution.
$657 en restitución, él ya pagó eso.
Sí.
And that was on the theft case, Judge. Y eso fue el caso de hurto, de robo.
Great. That's good. Good. I'm glad that you paid that.
Me alegra que lo haya pagado.
It's only fair.
Es solo justo.
Always the idea
Todo
here,
like
whenever there's someone that there's an alleged victim in a case, we want to make them whole again. And so thank you for doing this. That's great. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
¿Qué desea hacer? Yes.
How do you plead to the offense, sir?
Se declara la ofensa de manejo ebrio. Guilty.
I will find you guilty, sentence you to the agreement. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license. Otherwise, you will be right back in here with us.
Señoría.
I can if you want, but you'll have to get the dates to them. Okay. All right. Good luck to you, sir. Thanks.
Yeah, bring them out. Oh, okay. Bring them out. I got a plea and then two CJ's case coming out.
I guess let's do the plea
Wait.
while they're bringing them out.
NWA NNE.
NWA.
Is it Nguyen? Nguyen? Nguyen?
1A. The end of silence. Order in the court for plea.
After we're done right here, we'll go right here. And that's, you don't have to put anything, you won't pay anything, you just have that in, okay? It's what the current courthouse. That's first floor.
So
Time started on the video, Judge.
what do you do with yourself these days, Ms. Swanee? Sorry? What do you do?
I work at Whataburger.
Okay. Are you sure you want to do this? You realize it's going to go on your record.
Yes, sir.
You realize you're only making life more difficult for yourself, right? The more convictions you have, the more difficult you're making life. I mean, you need to understand that life doesn't get easier as you get older. It gets more difficult, and the more convictions you rack up, the harder life is. Just not many people are going to give you a job if you keep getting convictions. So no, I guess you don't want to do a deferred.
I asked her about it, Judge, and I told her that she could avoid the conviction if she did a deferred. She has no convictions that I saw. She said that she wasn't interested in that. I mean, if you're.
There is a type of probation that if you complete successfully, you don't end up with a conviction on your record. But that would be at a minimum, 9 months. You got to stay clean, no alcohol, no dope.
Order in the court.
You've no interest to try to keep this off your record?
I have a job to, keep myself busy, so.
Great.
I plan on staying out of trouble and staying out of the way.
But nevertheless, you're not interested in a probation to try to keep this off your record? Are you sure? Okay. You need to understand that this is going to go on your record. Once you plead guilty, you can never change this. This is a lifetime decision that you make today. The other thing that you need to understand is that if you ever run from the cops again, because it's an evading arrest, which is an enhanceable offense, they can use, if you ever pick up another one, they can now make it a felony offense instead of a misdemeanor, because they can use this to enhance you. You understand? Okay. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change it. So are you sure you want to do this? There were no other offers, I guess, no PTI, anything like that?
No, Judge. The circumstances following the.
I'm just, okay. If you change your mind within 30 days, perhaps we can do something if you get buyer's remorse. Typically, but you gotta understand, this is not a good day for you. This is not a good thing that's happening to you. You're only hurting yourself even more. Do you understand? Stop picking up convictions. Stop getting into trouble. All right, you know that from now on, it's a minimum of 90 days in jail. Minimum of 90 days for anything you pick up. All right, how do you plead to the offense? Guilty or not guilty? I will find you guilty, sentence you to, is it 3 days?
2 days credit for 2 days.
Oh, yeah, okay, 2 days in jail. Credit for the 2 days that you've done. I will roll your court costs so you won't owe anything. Good luck to you, Ms. Warren. Okay. Thanks.
Move up. You have Mr. Gonzalez and Mr. Rubio, they're both, waivers, Your Honor.
Okay. Gonzalez.
This is Gonzalez and Rubio. Yes, sir.
No.
Yeah.
I gave it to.
Good morning, gentlemen.
Buenos días, señores. Buenos días. Good morning.
Both of you guys are wanted from other states. And you are being.
Order in the court, please. I can barely hear the judge and I'm right in front of him.
You're being brought out because you guys are wanted for one reason or the other. You are Alejandro Gonzalez.
¿Ese es su nombre? Sí. Yes.
You're wanted for out of the state of California for receiving stolen property, motor vehicle, unlawful driving or taking of a vehicle, resisting, obstructing, delaying of a peace officer or EMT.
Demorando policía a un paramédico.
Are you waiving formal extradition?
Señor?
Are you waiving formal extradition?
No, I just signed.
Did you want the 14 days for them to come pick you up?
14 días para que ellos vinieran a recogerlo a usted? Sí. Yes.
And you must waive formal extradition.
Extradición formal. Sorry, I didn't know. Usted ya habló con su abogado, señor.
I guess.
I just believe the way you're, and he's understanding the question is being lost in translation, Judge.
Pregunta.
Do you want me to ask him?
¿Quiere que yo le pregunte? Sí, mire a su abogado.
¿Vas a renunciar a pelear que te extradicen? ¿Sí o no? No es ok, es sí o no.
Eso, si digo sí,
es lo que te vengan en 14 días.
es lo que más. Sí.
You want to waive formal
¿Quiere renunciar a extradición formal?
Sí.
Yes.
Mr. Rubio, you are wanted out of the state of Tennessee for first-degree murder.
Asesinato capital.
Are you waiving formal extradition, sir?
¿Extradición formal usted?
Okay.
Hablar más fuerte.
Yes. Okay, guys, we wish you the best of luck. Take care, and we'll wait for the respective jurisdictions to come get you.
Thank you.
Las jurisdicciones a buscar.
Brandon.
Morning, Judge.
Hey, man.
Your Honor, I'm here on Mr. Enriquez. Judge, this is he was on a, yes. Your Honor, he was on a he had to come back to prove that he did his IoT SOP classes. I believe he did, Your Honor.
He's behind it. It's like $860.
Ouch.
Oh, $930, sorry.
Come up, Mr. Enriquez.
He's completed everything else.
And Judge, he does have the,
So are they withholding all certificates until he pays it?
So these are the supervision fees, so all the fees associated with the program. I don't know if they want to waive the fees, that he could be done today, or.
I asked, I just emailed Brenda, and Brenda said they can't wait for probation, according to her.
The moment you pay these fees, the moment they dismiss these cases, when can you pay these fees?
I'm not sure. I don't want to give you an exact date and not fulfill with it, so.
You told me in the hallway potentially 2 months, Judge. They asked for a 4-month extension. Could we get 2 months?
He's gonna be under bond condition during that time as well, you know? You're gonna have to pay, longer you take, the more you're going to end up paying in the long run because you're going to have, what do you have now, an